I like to think that good legal thinking is critical legal thinking. There is no real distinction. But to be more specific about that, law takes place in two different places. I like to say that law is on the one hand a craftsmanship, so law is a practice that we do like craftsmen do craft out there in the world, in courts, in governments, in companies, in societies, and so on. On the other hand, law is also a scientific discipline. It's an intellectual discipline. It's a set of tools through which we try to understand the world. And we can situate it as such a tool in the academy, at the universities, law faculties. So to respond to the question, what is critical legal thinking, one has to first look at, well, what is critical thinking when it intervenes in the practice, when it's a part of the practice? And then the question, well, what is critical legal science when it operates at the university? If we look at the practice, then we can see that legal practice, or we should ask ourselves first, what is legal practice? Well, legal practice is a practice of using law, using legal arguments as language. It's both spoken and written language. And critical legal thinking takes place in legal institutions where competent lawyers who use that language critically try to influence the way these institutions operate. For instance, you might have been working for some United Nations institution and you are unsatisfied with the way the institution deals with the global or local problems that it starts to deal with. And you think that something about its inefficiency or its inability to deal with problems in a proper way has to do with the standard biases through which it operates, that its operational practices are part of the problem. And that at that point, a critical legal practitioner there tries to speak to his or her colleagues, tries to make arguments, competent legal arguments, so as to change those institutional practices. This is not to say that one would come from the outside and throw stones at the windows of the WTO. No, one would instead become a WTO lawyer and use the resources that WTO law, trade law offers, so as to change the direction of the law from the inside of the institutions. But in order to do that, you will have to have some distance from the daily operation of those institutions. You need to have critical distance. And that critical distance, in order to have that critical distance, you should constantly be engaged with the research and science, critical research and critical science, that tries precisely to pinpoint what are those legal practices that prohibit us from dealing with those injustices that we would want to deal with. And that connects then legal practice, law as craftsmanship, with law as an intellectual discipline as it takes place at the universities. And in universities, there one can say you can do research in two different ways. One of them is what researchers often do, normal science. It's perfectly legitimate and a good, important piece of legal science, which tries to answer this question. What is the meaning of Rule X, say? What is the meaning of the Vienna Convention on Law Treaties? What is the meaning of Article X of the Statute of the International Criminal Court? The outcome of this kind of research is a new interpretation, a new meaning. That's the normal work that lawyers do. Lawyers interpret instruments so as to produce new meanings. As I say, that's normal science. Critical legal science isn't like that. It doesn't ask that question. Instead, it asks a related but different question. This question: what does one need to believe in order to think that a norm has the meaning X? For instance, what should one believe in order to think that the statute of the International Criminal Court should be interpreted in the way X? So now the end result of this research is not a new interpretation. Instead, the result is an understanding of what it is that produces an interpretation. The result is a description of an interpretative context. What kinds of presuppositions lawyers and other practitioners have when they interpret treaties in particular ways. And now let me connect these two things to each other. I said earlier that critical legal thinking in practice is that you participate in the legal institutions as a competent lawyer, using the languages, the rules that the institution consists of and that operates competently. But you use that language and those rules and institutions, but in a way so as to employ the insights that you have received on the intellectual side to the question as to what should I believe? What should I believe if I were to interpret the normative materials that my institution uses in the way that the institution usually interprets it? And if the case is that the institution has not been able to deal with the problems it has dealt with, then the end result must be that the assumptions through which the institution operates are wrong or inefficient, or that those assumptions make the institution itself incapable of correcting the injustices that you have. And in this way, and then you replace the mistaken assumptions about the world with other kinds of assumptions. Those mistaken assumptions might be, for example, that a certain type of economic relationship is beneficial irrespective of where it's being employed. And once you think about an assumption like that, then you might try to figure out what, and you see that the assumption creates results that perpetuate the injustices that you want to eradicate. Then you might ask yourself, well, what other assumptions might I use so as to be able to utilize this institution so that it better deals with the injustices that I want to eradicate? So this is a long explanation to response to the question, what is critical legal thinking? I said critical legal thinking in institutions, in practice, is one thing. It is the use of the institution for purposes that the institution has not normally been used, namely efficiently. And critical work in the academy is to ask questions that academics have usually not asked. Academics ask questions, how should I interpret this treaty? What is a correct policy proposal in this field? Whereas critical thinking asks the question, what should one believe, or under what presuppositions this treaty should be interpreted in the way X, or this policy should be implemented in the context Y. Why would one need something like critical legal thinking? I think all international lawyers, students, academics, professionals, take up the field of public international law in order to improve the world, to make the world a better place. So in some ways the profession and the field is based on the premise that the world is an unjust place. And I think we could agree with most people also who are not professional that the world is very unjust, and that we have to deal with the injustices, especially inequality, wars, famine, extreme poverty, and so on. Now, standard legal thinking, ordinary legal thinking in international law as well as elsewhere has not been terribly efficient in eradicating and or dealing with these problems. Something new is needed, and this was already, of course, known some time ago. Legal thinking started to turn critical in the 70s and 80s when it started to suggest that it's possible that law itself, including international law, is some way participant in the daily production of injustice and inequality, poverty, and other things that we wanted to eradicate. So the suggestion is that law is not automatically an instrument for making the world a better place. law in some significant ways actually responsible for its own part of the injustices that reign in the world today. And the thinking turns critical when it starts to examine precisely how does law contribute to the injustices, how does law itself produce injustices, how does law make it in some cases more difficult for us to deal with the problems that we want it to deal with. So the suggestion is that law is already everywhere in the world. Law is not something that comes to an unjust world from the outside to correct its problems. Instead, the world with all its problems has already been produced and is being sustained in part by law. And so critical legal thinking starts from the premise that there is no reason to take a moral attitude towards law itself, no reason to believe, as previous generations sometimes have, that merely by having law you will solve the problems. Law is both an instrument for problem solution, but, and perhaps more interestingly and importantly, a producer of those problems themselves. And that's why we need critical legal thinking. We need thinking that tries to study and explain just how it is that law operates in the world to, for instance, maintain the global inequality between the North and the South. What are the legal structures that operate so that poverty concentrates in other places, and some places, and wealth in other places? We can look at trade law or investment law, for instance, from that perspective. But we can also look at, let's say, human rights law. That's a law which has, of course, a well-known ambition to eradicate injustices and human rights violations, and often it does this. But it doesn't only do that, it does other things as well. For example, it tends to proceduralize and legalize issues that actually at their root are issues of economic and structural injustice. By legalizing those issues, thinking of them as right violations of individuals, it's hard to begin to deal with the structural economic injustices, the historical injustices that underlie and produce those injustices. In environmental law, we've seen a large growth of environmental treaties, for instance, in the past 20 years or so. But nevertheless, we know that the climate change is going on, that pollution is spreading. There are some places that are being destroyed by industrial and polluting activities. And the suggestion might be that the existing international environmental law actually creates just an illusionary regime. It provides a smokescreen behind which those kinds of industrial productive activities that cause pollution may continue. So instead of being an effective remedy, it offers us, in some cases, not a remedy at all, but gives the politicians a way out from actually dealing with this. They sign a treaty and believe that, well, the world has become a better place, but not one person's situation has improved by the signing of the treaty. So these are just some random examples of how law makes correcting injustice more difficult, or actually participates in the production of injustice. And critical legal thinking wants to grasp at law precisely at those points when it prevents us from doing what it is that we all want to do, to deal with problems of global and local injustice. So my present work is work in international legal history. And I feel that historical work in the field nowadays, which is spreading around, many people are doing more and more, they find that this is a good moment for doing historical work, and I agree. So that historical work is often important for critical purposes. It's especially important because when you study the past, you will find that the legal regimes, the legal resolutions that we have used in the past are very different from these techniques that we use in the present. Now, if the starting point is, and I suggest that critical starting point always is, that the present is a very unjust place, then your ability or the knowledge that you produce from history gives you alternative ways in which the world has been ruled and regulated in the past, and that those knowledge of those alternative views gives you two important insights. One that it gives you is that the present way that the world has been organized is an outcome of a series of choices at particular moments in the past where those choices could have gone other way as well. So the present is a product of a political past, of choices by ambitious men at crucial moments, decisions that have been made as a result of political struggles. The second way in which this has a critical impact is that it frees us from the sense that our present is necessary, that it's somehow natural. Historical study shows that the present is, if it does, as it does, show that the present is the outcome of struggles and decisions that could have gone the other way. Then we are freed from the sense that, we are imprisoned in a present that cannot be any other way than it is. We often feel that there is something necessary about the present, and critical thought finds that feeling a problem. So in order to change the world, we have to know that the present isn't necessary. It doesn't bind us to the social and legal arrangements that we have. And we can receive resources from the past so as to instruct us as to, well, what alternatives are there available? How can we operate our institutions in ways that aren't the same that we've been doing now? Our imaginative capacities are being opened by that kind of historical work. And then the final thing I want to say is that historical work also shows us that the present is a product not only of choices by ambitious men. Unfortunately, most of these authoritative people have been men. Not only that the present is a production of those choices, but also that those choices have always been conditioned by larger structures. Words such as, we have spoken in this conference a lot about imperialism. Historical work shows us that actually imperialism is responsible for much of what international law is like. It's quite true that international law has sometimes been used as a counter-imperial device. But every imperialist has always had their international lawyers, and every empire, including the present, uses law in order to buttress its position and to try to perpetuate itself. Historical knowledge gives us both of these two things, an understanding that the present could be otherwise, because there are human beings who have chosen this, and that the present is also a production of larger structures. Human beings have made their decisions in structures such as imperialism, nationalism, Christianity, ideas about civilization, ideas about money and profit, which all have contributed to the present being the way it is. Therefore, to summarize, historical research enables us to step a little bit outside our present and to look at this present as strange and incomprehensible. And that sense of strangeness and incomprehensibleness allows us to say that the injustices that we see are not necessary. The injustices that we see do not have to be tolerated because of the way the world is. The world is open, is what the historical studies tell us.